Mama's in the living room watching Judge Judy. I'm in the kitchen eating leftover sushi. And she yells, oh, girl, you gotta hear this one. A man was arrested for running a theme park. And when they said, where's your license? He said, my dog ate it. Oh, you can't make this shit up. Sometimes I wonder if life's just one big cosmic joke. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on her Prosecco, makes fun of all the weirdos, and then I hear her shout, girl, you gotta hear this one. Mama loves to laugh at how absurd life is, says it's all a comedy and I'm her audience. And I love the way she makes fun of the world. She said, you'll never guess what's with their girlfriend. It was a man who didn't get us out of the bed. He said, I've been through hell and now I need some help. You just can't make this shit up. You just can't make this shit up. Sometimes I wonder if life's just one big cosmic joke. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout, girl, you gotta hear this one.
So, after a year or so, Sarah Boone's appeal is finally in. Well, she's not arguing she didn't do it. She's arguing that the trial was unfair. So the question is, does she have a point? Are there real legal errors? We're going to look back at the stuff that we saw in the trial. We're going to compare it to the document. And we're going to decide for ourselves what we think the trial court will, or the appeals court will do. However, welcome if you're new here. I'm Squid. I break down legal documents in the eyes of someone who is not a lawyer and who despises 99.9% of lawyers. So we're going to actually go through Sarah Boone's appellate brief. We're going to look at what the highlights are, look at what they're arguing, and we're just going to get to the facts and not the headlines, because we did cover Sarah Boone on this trial. Sarah Boone was actually the first trial I covered where I was monetized, so it's kind of a big deal for me. But anyway, how is chat doing today? We're gonna an Unhung Hero. You cannot fix her. But Unhung Hero, thank you for the $5 super chat. Rest in peace, Jeff. Legal Vices. He's who I found out about this trial from originally. Yeah, I think it was him and Mo in the Deep End were who I found out this trial from. Jeff was one of the lawyers that I actually did respect and really liked. And Unhung Hero, thanks for the 20 Squid Pro Quo memberships. I appreciate you so very much. Feeling kind of spicy today, so left the hair. It's still kind of damp. It's all crazy today because I'm feeling a little crazy. Feeling like a selfish bitch today. Let's put it that way. Okay. And King Bob's Queen, thanks for being a member for 9 months. Hard for me to unpack all the Sarah Boone stuff. Yeah, it's a lot. I do have the transcripts of her trial, which we may get into. Sometime. I just haven't had the time or energy to put into Sarah Boone because she's drama on another level. Ma'am, you have Nutella all over your face. All right. And hey, Flash fan, how are you? Good to see you. All right. 9 months. That's longer than any Laura Owens fake pregnancy. Hey, Roy. All right. Stop faking. Stop faking what? What? Wait, what? Stop fake. What am I? Okay. I'm confused. All right. Let's get into this document because it is 30 pages and we are just going to hit the highlights because she's definitely interesting. And Island, it's so good to see you. I'm streaming as well. Let's see how this works. Oh no. Yeah. I did notice it, but it went over my head. And hey, Stats, how are you? Thanks for the $1.49 super sticker, and it's so good to see you. Pay attention, Flash fan. All right, let's get into this. There we go. Make it just a tiny bit bigger for y'all. All right, appellant's initial brief for Polk County, Florida. Her attorney is David Maldonado. We'll see what he chose. I read, girl, get that out of your mouth. I read through this and I'm just confused on why certain things were brought up and why other things weren't brought up. Ma'am, you're going to have to. So, for those of you who weren't or who have no idea who Sarah Boone is, Angel, you're going to have to get down. Then you're going to have to be quiet, okay? Okay, thank you. All right, this commenced with an information being filed against appellant on March 23rd, 2020, charging her with second-degree unaliving, which allegedly occurred February 23rd, 2020 in Orange County. The incident gives rise to the information on February 24th, where the appellant and the victim, her boyfriend, Angel, you have to get down. You have to get down. You have to get down. I know. Mommy's mean. She's gonna go tell Daddy. Go call Daddy and tell him how mean I am that I made her get off my lap. Hey Silver Fox. Hey Florida Flipper. How are you? Silver Fox lurker check in. Yeah, no, let's not. We have a lot to get through, and I want to make sure that we actually get through it all. And thanks, King Bob, for the 5 Squid Pro Club memberships. So they give a brief history, but they're giving it from Sarah's perspective, which is not entirely the facts. I'm just, you know. All right. And it sounds ridiculous because it is. When the appellant and her boyfriend were sharing a bottle of wine and decided to play hide and seek, wherein the appellant had gone upstairs in their apartment to hide. After the victim did not come look for her, the appellant reportedly went back downstairs to discover the victim zipped up in a suitcase, and both parties were laughing as she finished zipping up the suitcase. And the victim purportedly was able to stick a few of his fingers outside the suitcase as it was not zipped all the way. The appellant then went back upstairs in their apartment and fell asleep under the assumption that the victim could get himself out of the suitcase. She is not pro se, but she did go through a couple of appellate attorneys. The next morning, she woke up and did not see the victim until she went back downstairs to discover the victim had died in the suitcase, at which point she called her ex-husband. Not 911. She called her ex-husband. I'm sorry. That was my first red flag. Well, second red flag. Who in turn directed her to call 911 like a normal adult. A search of the appellant's cell phone revealed 2 video recordings where the appellant had explained that he could not breathe, and the appellant replied, "Yeah, that's what you do when you choke me, and that's what I feel like when you cheat on me." According to the arrest affidavit for the appellant, the victim's autopsy revealed he had various injuries, and after investigating detectives showed the video recordings to the appellant, with her denying any recollection of the videos after 1 bottle of wine. They shared a bottle of wine. So she had less than 1 bottle. I'm sorry. Red flag number 364. She was placed under arrest. After the information was filed during the first few years of the incident case, the trial judge entered an order on June 28, 2024, highlighting the appellant's extreme difficulties with retaining defense counsels. The order revealed that the appellant had gone through 8 different counsels, and all counsels had moved to withdraw due to general irreconcilable differences with the appellant. Sarah has a difficult personality, to say the least. There was a few that withdrew due to conflict of interest, but there was a lot going on. And she was the one who wrote letters to the judge, which we definitely made fun of. And Sarah, I'm about to make fun of you. Finding that the appellant was no longer entitled to counsel, the trial court found that she had forfeited the right to counsel, and her conduct forced her to proceed with the case pro se. This is interesting to me because they're bringing this up in like the case background, but it's not one of their it's not one of the things that they're using as an appellate point. That was surprising to me because I thought that forcing her, quote unquote, to be pro se would be one of the biggest issues that they would have on appeal. But once again, not a lawyer. Maybe I'm wrong, but yeah, she definitely keeps things interesting. I'm just, she better not get a new trial like Letitia Stotch. There's a couple things in here that we'll get to that I am actually not sure. I am legit not sure, but I'm also not a lawyer, so you can take that one with a grain of salt. But from my, trying to play devil's advocate and see both sides of things, I don't have to like someone to see their point. I'm not sure. Well, you'll let me know what you think. Yeah, he did back that up very well. But there's a couple things that at the time I didn't see as an issue that we'll get to. And I thought the judge explained himself really well. But I'm not sure how this is gonna go. But and hey, Anaya Print, how are you? Been fighting with the company to get one of my things replaced. Technology is great until it's not. Despite the significant setbacks, the appellant was able to obtain new counsel, James Owens, which, who enters appearance on her behalf, August 30th of 2024. Subsequently, after the appellant's new trial counsel enters his appearance, a flurry of motions and responses I have to go do mama duties for a minute. Y'all have a quick intermission.
Our hearts beat to the city streets. We began to feel the fire. We rise like tall buildings as the chemicals they take us higher. The night's young and it's just begun as she puts her hand in mine. We wanna chase the night, wanna dance to the light, pull the stars from the sky, just two hearts running wild. Never sleep, never stop, as we shout from the top. We're gonna be two hearts running wild. hearts running wild. The moonlight, summer sky, it was the best we ever had.
Hey guys, sorry it took me a little longer. I had to clean up a little bit of a mess because someone still likes to tell me, hey, I'm peeing, instead of just going sitting on the goddamn toilet. Excuse my fucking French, but I'm really just getting sick of this shit. Having a day. Hey Kasha, I'm not sure what happened to my membership, but I renewed it. Yeah, events like today are and thanks for becoming a new member, Kasha. Why I remembered that I just don't give a fuck. Yeah. Anyway. Yeah, that's not why I'm frustrated, but you know, events like today make you wonder when someone says, I don't want to be a part of something, yet runs their fucking mouth. You're a part of something, whether you want to be or not. Yes, if you have a problem with my choice of Mama Judy interlude music, scroll on and file your complaint with our Focus complaint team. And for those of you who need to know what the acronym FOCUS says, it's fuck off because you're stupid. Just saying. All right. After he entered his appearance, a flurry of motions and responses were filed between the parties during the later part of 2024, with the trial court ruling on various pretrial issues presented. Trial began October 14th of 2024. Hold on one second. YouTube is being funky. My stream just crashed. Here we go. All right. All right. With jury selection, appellate's trial counsel had asked for a motion in limine to prevent the defense from posting a battered spouse syndrome defense theory. She wanted to use that, he beat me up all the time, so I was just defending myself. Blah, 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 whatever. However, the trial judge issued a mixed ruling on that motion. While the trial court would not completely exclude the defense, the trial court did rule that the defense would need to lay a proper predicate before the defense expert would be allowed to address the battered spouse syndrome. Seems like common sense. Yeah. No, it didn't. That was me. Specifically, as it like I said, I'm having a day. I'm spicy today, and I'm spicy. And I'm not spicy in the fun, let's make fun of someone way. I'm spicy in the don't fuck with me, I will time your ass out kind of way. Just having a day. I was hoping that this would be a little bit more fun to make fun of Sarah Boone, but it's just, I actually kind of agree with some of the crap in here, and that's putting me in an awful mood. Gail, it's not the fun spicy. It's not the fun spicy. It's the my goal is to make people cry today kind of spicy. Like it's not the fun spicy. It's the I want to Like, oh, if it looks could kill kind of spicy day. I thought this court stuff from her was over. She's doing jail time for deleting somebody. Yes, however, you always have the right to appeal. Does anyone know if this lawyer met with Sarah? I don't know. I haven't seen, but I do know she was putting in some motions with the court that she was not happy with her appellate lawyer, and she had never talked to them, and oh, fucking know. It's Sarah. What she says goes in one ear and out the other. You know. Yeah, I'm in grizzly bear mode today. I'm in mama bear mode, but it's not mama. It's just bear. Oh no, I'm fine with y'all, but it's just like we're gonna get through this, and we're just gonna get through this, and like we're just not gonna like try to derail me in the funny way that y'all like to derail me, because I'm just not having it today. That is true. That is true. I will not, but that's what, honestly, that's what an appeal brief is. It's cherry picking what you thought that the court got wrong. And it doesn't argue guilt or innocence. That's the one thing people tend to get wrong about an appeal. Because appeal doesn't actually argue guilt or innocence. It argues whether the trial court screwed up or not. And that's one of the reasons that judges walk this fine line. And I don't agree with all judge decisions, and I'm not saying certain things, but in certain cases, when you see judges make decisions that even they don't like, it's because they're making decisions that they think will be appeal proof, not decisions that they necessarily 100% always agree with themselves. So, you know, and it's good to see you, common sense. So, but it's a panel of 3 judges, and I don't know if it'll be enough to, you know, but like I said, I'm not a lawyer, and I'm definitely not an appeals lawyer. Yeah. Yeah, appeal is based solely on the law. Recognizing the risk of error with its request, the appellate's trial counsel asserted that the impaneled jury should not hear about any prior instance of violence unless there is testimony that self-defense that's recognized under the state of Florida's laws. A discussion between defense counsel and court ensued that only ensued about the defense expert's, Dr. Harper's, deposition previously taken and what her opinion on the appellant's battered spouse syndrome was based on. The trial judge inquired as to what the overt act would be that would give rise to the appellant's self-defense theory, and the defense counsel responded that he was being put in the position now to disclose what our view of the overt act is. And that's this one, it's T, it's transcript. The R is the record. This is the transcript, and I actually have the entire transcript on my computer. It's a lot. After disclosing the defense theory of the overt act, the trial court ruled on the matter as outlined in the preceding paragraph. The trial court also denied the appellant's renewed motion for statement of particulars. After dealing with a number of motions, the trial court then conducted a Richardson hearing on a number of late disclosures that the defense objected to, and the trial judge found that any discovery violations by the appellee, which is the state, were inadvertent. And King Bob's Queen, thanks for the gifted one Squid Pro Quo membership. That went to Anne. Nice job. And we will be starting members only again on Monday. We just had to get through some stuff this week, and there's more in that case. I just really don't care. you know, like I don't have. There's certain things that when you don't have time, you just that go by the wayside, and certain Florida cases are one of them. However, this Florida case is not. All right. After the jury was impaneled and before the trial on the matter began, appellee's trial counsel indicated to the court that there was an issue with the appellants attempting to use demonstrative aids during opening statements. The trial counsel reinforced or referenced the court's initial ruling on the overt act issue to argue that certain photos of prior injuries to the appellant and boards outlining the laws on jury instruction should not be shown during the appellant's opening statements. I would have to look at the case law for this, but it just seems like this seems like a silly argument to me that we weren't allowed to use demonstratives during our opening statements. So we're going to appeal. We weren't allowed to use demonstratives that showed prior injuries because the judge told us we couldn't show prior injuries unless it came in through testimony. Like it I don't know if they could. I don't know if they necessarily do, but generally it goes to an oral argument. Like Carly Gregg's appeal brief went to an oral argument, which is next month. Holy. However, my assumption is that they could. I can't honestly remember the last time I covered a criminal appeal, so it's a little different than a civil appeal. Like I said, not a lawyer. I'm just going by memory of what I've seen. However, I don't see why they wouldn't, because they're going to have their side of the story, and then the court's going to look and go, well, should we hear oral arguments, or are we going to take this and go, yeah, no. Yeah, no. So I'm really hoping that they just say, like, that's not enough. Prince Ponce de Leon was looking for the fountain of youth in Florida way back when. I think he found the fountain of stupid, and many have drank from it. I think it's the heat, y'all. It's got to be the heat. It does something weird. The trial counsel referenced the court's initial ruling on the overt act issue to argue certain points of prior injuries to the appellant, and boards outlining the laws on jury instruction should not be shown during the appellant's opening statements. I don't even want to pretend to try to get into that brain. And I love psychology, but there is certain things that there are certain brains that I just don't want to have a peek into. And hers is one. Okay. What heat? It's cold as F here. Well, it's 85 degrees outside right now. And Ung Hung Hero, thanks for the $2 super chat. After the court reviewed the proposed photos, the court agreed with the appellee and prohibited the appellant's counsel from using the demonstrative aids. I will be right back. Mama duties. Oh. There we go. Not in Florida, it's not. Huh. All right. So the evidentiary portion of the trial matter began on October 18th with several witnesses called by the appellee. Trial thereafter continued for several days with numerous witnesses and publication of various evidence, including portions of video taken from the appellant's phone. Be careful what you record. We haven't figured out from Mama Mo, Miss Mo in the deep end, if you are going to be stupid enough to do something, don't record it. After the trial judge denied the appellant's motion for judgment of acquittal, everybody does that in between the state and the defense. It's kind of like standard issue. The appellant was called as a witness for her case. She testified generally about the incident in question, what led up to the victim's death, her fear of the victim as he was attempting to get out of the suitcase that he was zipped up in, based on his prior acts of violence against her, and the aftermath that she discovered he had been deceased. Additional witnesses testified for the appellant, and after the appellant rested her case, the appellee presented rebuttal testimony from Dr. Warner. While testifying as to her 2.5-hour evaluation of the appellant, Dr. Warner opined that the appellant was not suffering from any PTSD that could lead to battered spouse syndrome. The appellant's counsel objected. A very lengthy discussion ensued between the counsels and the court. I remember this specifically because James Owens was sounding like he wasn't whining. He was whining more than she was. Hello, little one. Ready for that pecuniary advantage? No, you're ready for that nap.
No.
Are you ready for a nap?
Yeah.
Yeah. Okay. Go sleep. All right. 63 in central Alberta. You can have some of our heat. It rained yesterday and it rained this morning. I'm so happy. A very lengthy discussion ensued in the court as the appellant's counsel claimed a discovery violation, pointing out that Dr. Warner had previously claimed during the deposition that she had a different opinion and diagnosis of the appellant that was now being offered at trial. The trial judge acknowledged the different opinion. The court held a Richardson hearing. After considering the argument, the judge decided to allow appellant to conduct an in-camera deposition, acknowledging that discovery violation was substantial and had an impact on the ability of the appellant to properly prepare for trial. This is where I think they might have a point. 1 point for Sarah Boone. I think it's her only point, but it might be enough. I don't know. It might be enough. It is one of those situations where you're just like, I just not sure, but it's plausible. And sometimes the plausibility is what you need. It's just ma'am.
Mommy.
All right. During questioning from the appellant's counsel, Dr. Warner claimed that she had not previously disclosed her opinion at the appellant during the initial deposition because the appellant's counsel didn't specifically ask her about that. So I remember being in my car listening to this because I had to drive from the tiny little town to the big old city, and I remember yelling at my phone like, you didn't ask her in a deposition. Remember how I've said in a deposition, if you're not asked, don't tell? Well, this was kind of the epitome of that. They didn't ask her, so she didn't offer the information. And it was kind of like, well, whose fault is that? Is that the defense's fault for not asking the question in a deposition, which, to be fair, surprisingly enough, I can still do that, is not James Owens' fault, because he was not her counsel at the time these depositions were done. So, Angel, stop. It's one of those situations where it was like, I don't know, this will be interesting. After the appellant's questioning concluded, trial judge observed, this is your opportunity and only opportunity to cure any prejudice. In response, the appellant's counsel protested that he was forced to take the deposition on the fly, and he was put in a very difficult situation because the judge again reiterated that he was giving the appellant the opportunity to cure that Richardson issue. Again, later in the deposition, appellee's expert revealed that her opinion had changed from the timeline of the initial deposition to the day of the trial. Namely, her opinion that the appellant did not suffer from any type of anxiety or adjustment disorder. This right here is the issue that I have. I don't think she was pro se at the time of these depositions, but I don't honestly remember who her lawyer was. These were pretty early on in the situation, and she didn't become pro se until either late 2023 or early 2024. So no, I think Malin's talking about when the depositions were done, if she was pro se. She wasn't pro se for any depositions that I'm aware of. So I think she might have been in between lollies. I don't remember. Yeah, it was a revolving door. It was a revolving door of lawyers, and it's like, it's kind of one of those things where it's 3 years ago now. Really hard to remember her lawyers 3 years ago. But I can look. No, you're fine. I understand that sometimes when you only have so many characters, and especially with the delay in chat, yeah. Wasn't that old man that helped her with the family court too? I don't know. The family court stuff is sealed, so if I can't access it myself, I don't have sources. This is just me, a one-woman show. So yeah, I have people who tell me stuff, but like, I don't have anybody who gets me documents or gets me leaked documents or anything like that, because I don't have that kind of pull. I'm just an OTA. So yeah, during the trial, he was able to depo her like mid-trial, but her original deposition was most likely in 2023 or even 2022. And because she was a witness or an expert for the state, they probably had her early. She might have been in 2022. Because remember, this crime allegedly happened in 2020, February 23rd of 2020. So it was 4 years before it even went to trial because of her issues with lawyers. So there was a lot going on. But the pre-trial deposition was done by somebody else. Yeah, but they reviewed the transcript. Yes. An extended argument from both parties took place with respect to the instruction as it related to the initial aggressor duty to retreat issue. And this is also a big thing, because if you're the initial aggressor, like, and zipping someone into a suitcase being the initial aggressor. No, it's Hung Hero, thanks for the $2 super chat. One woman show, Freddie and Flip. No, but the phrase is one man show. You know? Yeah, right before the shit hit the fan, so to speak. After the parties went over jury instructions, court provided those instructions to the jury. Both parties presented closing arguments prior to deliberations, and the jury found her guilty. Sentenced her to life in prison on December 8th of 2024. life in prison. Notice of appeal was filed December 8th of 2024. So December 8th of 2024 is when the notice of appeal was filed. Y'all know what month and day it is. It's April 29th. I was sent this yesterday. So, what, 18 months? It's all right. Getting to the actual argument. So, ultimately prejudiced the appellant's ability to present a viable defense, prejudiced her trial counsel's ability to adequately prepare for trial. Improper limitations were placed on the appellant's counsel's opening statements, which prevented the appellant from properly framing an adequate defense. Florida courts have held that opening statements can be a critical opportunity to frame the case, and that unduly limiting statements can prejudice a jury's understanding of a theory of defense. The trial court essentially allowed a trial by ambush. All right. So the issues that they have: limitations on opening statements, appellee, the state's discovery violations, erroneous jury instructions, admission of expert opinion on a factual issue, and then applicable standards of review are outlined in the argument. Down. Okay. I love you. Up, down, up, down, up, down, up, down. Okay, stand up. Well, you just said down. Girl, I gotta get that big old knot out of your hair. I thought my alarm went off in the other room. You have a great microphone. That was her. That was her iPad. State's response: everything the defense said is bullshit. Thank you. Pretty much. Oh my goodness. Trial court erred in improperly limiting the appellant's opening statements. The trial court ruled that the appellant could not introduce evidence on the victim's prior violence to frame a battered spouse syndrome context, and thus forced the appellant to provide a limited opening statement that did not properly frame the appellant's theory of defense for the jury. This violated her right to present a complete defense, and this is an error. Generally, the purpose of an opening statement is to outline what a party in good faith expects to establish during a trial. This is where it is kind of like, I see the judge's point in what he did when he was doing it, but hindsight being 2020, I'm kind of looking at it like, does she have a point? I don't like Sarah, but does she have a point? I don't know if it's enough to get a new trial, but it's definitely an interesting argument. All right. Wide latitude is usually allowed with opening statements, and trial court's limitations on such statements will be upheld if there's no abuse of discretion. Concerning a self-defense claim, as the appellants asserted in this case, a defendant must show evidence of an overt act by the victim that showed a need for the defense to exercise self-defense. And this is what didn't make any sense to, I think, the judge, was you zipped him in there. What was the overt act? And that was what was confusing the judge, if I'm remembering correctly. We might go back and look at some of the highlights of her trial in the next few weeks. But you zipped him in there and then recorded him and then left him. What was the overt act that caused you to fear for your life? Because in a self-defense, and this is why they went with battered spouse instead of self-defense, in my opinion, because in self-defense, you need to show that you were in fear of your life, serious bodily harm or death to you or someone else. Is sitting on the couch recording someone begging for their life in a suitcase? Now, if she hadn't recorded herself and then willingly handed over her phone to the cops because she did that on body cam willingly, like she had nothing to hide. That's the interesting conundrum. So if everyone could get a new trial just because they don't like the verdict, everyone would be appealing. And a lot of people do appeal. If she gets a new trial, who would be her lawyer then? I mean, come on. I know, right? With that being said, if she does happen to get a new trial, I will be covering that trial. I will make time to cover that trial because I covered the first one. And Heidel, thanks for being a member for 9 months. Woohoo! Tentacle Nation, baby. All right. In the case at bar, the appellant asserts that the trial court unreasonably restricted her counsel's ability to frame her defense until an overt act of aggression by the victim on the day of the incident was established. The ruling forced the defense to present a naked opening statement. Phrasing. Prevented them from showing photographs of the appellant's injuries or fully explaining why she acted in self-defense until late in the trial. This violated the appellant's right to present a complete defense and properly frame the case for the jury. I'm not sure, Trial court ruled you can talk about it that the appellant was a victim. You can talk about some incidences that may have happened, but I'm not going to allow the photographs at this point in time. Here, wouldn't this be arguing against yourself? You can talk about it that the appellant was a victim. You can talk about some instances may have happened, but I'm not going to allow you to show photographs for utilization in opening statements. Isn't that arguing against yourself when you said that you weren't allowed to present a complete defense? You were. Yeah. Have a good night, Malin. And Gail, thanks for being a member for 18 months. Heidel, I'm 18 months old. I feel really old. Oh my goodness. 18 months. That's about the time that's literally about the time that Sarah Boone's trial started. Because I got monetized the week of her trial, I believe, if I'm remembering correctly. There's just some things that you don't forget. The trial court strictly applied the overt act requirement to opening statements, ruling assuming that overt act hurdle is not met, the evidence was excluded. Yeah, that's true right there. Like, it's only introducing and giving an outline of your case. It is not your entire defense. Your case in chief is your entire defense. Like, I got nothing. Like, I don't know. Like, this one, I'm not. This is why the only one that I'm sure might stand a chance is the expert witness. It's preventing the appellant's defense counsel from laying foundation in opening statements, prior violence from the victim, creating reasonable fear in the appellant. I believe that she believes the appeal means she'll get to go home. I don't think she realizes it's only a new trial. You bring up an excellent point. An excellent point. I think you are 100% accurate. I think that Sarah thinks that if her conviction is overturned, that she gets to walk out of jail or prison. It's laughable to me. It's laughable. It's yeah. And Kid Bob, thanks for being a member for 19 months. Jeez. Gail, 18 months. You're young. Great stream, Squid. Thank you. It's Sarah's queen of Delulu land. She's been drinking the Delulu lemonade way too much. Or in Sarah's case, chief in a suitcase. Chief in a case. Yeah, Samsonite Sarah. As the Florida Supreme Court observed, opening remarks are not evidence, and the purpose of opening argument is to outline what an attorney expects to establish by the evidence. You said self-defense. I mean, there's my pushback on that. You said self-defense. There's various types of self-defense, which you will be able to present in your case in chief. We're chief in case. I'm never gonna say case in chief again the same way. It will forever and always laugh when I say that now. Thus, prohibiting photographs of the appellant's injuries and full explanation of abuse history left the jury without context for the appellant's actions, forcing the delayed presentation of the defense theory. In a case hinging on self-defense and battered spouse syndrome, this likely affected jury perception and was not harmless. Yeah, Saint Sarah of the Samsonite. The trial court did not provide an adequate remedy for the appellant or to the appellant for the appellee's substantial discovery violation. Discovery violations, in my mind, are a huge deal. So this is where I think she might have a point. Once again, doesn't say that I have to agree or think she's innocent to understand that she might have a point. But the thing about an appeal, like I believe Roy said earlier, you get to cherry pick what you want. That, you know, so appellee's expert witness crucially changed her opinion against the appellant in the middle of the trial, resulting in trial by ambush. During a pretrial deposition of the appellee's expert witness, the witness indicated she did not have any opinions on a diagnosis of the appellant. I would like to see the look at the transcript on that one, because I just don't think I think that was taken out of context. However, at trial, the witness then claimed that the appellant did not give me enough information to diagnose her with PTSD. Although the trial court recognized the change in the witness testimony from what she had initially stated, she learned the judge only allowed an on-the-fly deposition in the middle of the trial. Rule .3220 of Florida Rules of Criminal Procedure generally governs discovery processes and requirements in any criminal proceeding. Under this rule, depositions of witnesses are allowed, and parties are under a continuing duty to disclose additional witnesses or material that materially alter a written or recorded statement previously provided under these rules. I mean, Sarah must have drank too much Boone's Farm. Yeah, to only have to share a bottle of wine and not remember videoing somebody begging for their life on camera. And then, yeah, that's blackout level drunk. That's not, yeah. I wasn't paying attention to this game out. I heard a few people talking about it, but wasn't paying attention. It seems stupid to put someone in a suitcase, film it, and then show the police. Yeah, we watched the body cam, and she really did show the police. We really did. And hey, Harry. It's just a... So, under the rule, the court will conduct a Richardson hearing, and that's Richardson v. State. In cases dealing with a state violation of the discovery rule, a court will consider questions such as whether the state's violation was inadvertent or willful. I think this was inadvertent. because the witness was like, well, you never asked me specific questions about it, so I couldn't give you an answer. Oh, here we go. Comes now, not Sarah, in court or otherwise. Y'all crack me up. And Uncle Girl, thanks for the another $2. You are awesome. Oh my goodness. Willful, whether the violation was trivial or substantial, and most importantly, what effect did it have upon the ability of the defendant to properly prepare for trial? If I was them, trial by ambush would have been them not delaying the case because she had new counsel and time to catch up. Is she trying? I'm a little groggy, but I'm going to ask anyway. Is she trying to get away with murder on a technicality? Yeah. Well, the thing is this will give her a new trial. Here's my thing though. Like Trish Jackson's mom said earlier, I think Sarah thinks this will let her get out of prison. And that's not the way that it works. You will get a new trial. Another opportunity to it was reported that she pushed him down the stairs while he was still in the suitcase. Yeah, and if you actually look at the pictures of the suitcase is on its bottom. Like, it's not the way you would. So when we get done with this, I will open the picture of the suitcase if I still have it. Please tell me I still have it. Please tell me I still have it, because that would be amazing. That would be amazing, and I didn't delete it. Oh my goodness, that would be amazing if I still have it. Let me. Oh my goodness. Because I was using it for. Oh no. Oh no. I was using it for my thumbnails. However, oh, there we go. So when I will just share this. Download. So I'm going to stop sharing this for a second, and I'm going to open up the picture of the suitcase. So if you actually look at the picture of the suitcase, that is not the way that you get into a suitcase. And that is the suitcase. And unfortunately, that is, rest in peace, that is the suitcase. Because, I mean, if you were to zip somebody into a suitcase or zip clothing into a suitcase, you flip that over. Yeah, that's the backassery side. Yeah. That's the side you usually lay flat down on the bed, the floor, wherever, and you unzip it from the front. That's the way that the suitcase was found. This picture was taken by either from her video or by crime scene techs. I think this was her video, which means that at this current time that we are looking at this picture, he is still in that suitcase. It's just one of those things of like, it was never proven that she pushed it down the stairs. It is just one of those like plausible things that you look at the suitcase the way it's laying and you look at his injuries and you can kind of infer what happened, because there's no way that you jokingly zip someone into a suitcase. Yeah. Yeah. I mean, and would you be able, if you were drunk, like they were both drinking a bottle of wine, but we can assume that they were both drinking more. Would you be able to unzip yourself with the zipper like that? First video, second, she had flipped it over. Thank you, Anne. Like, thanks for the $2 super chat. Congratulations on finding that suitcase picture. In my thumbnails, I used to be as realistic as possible, like super realistic. And this was the photo that I used in my thumbnail. So you can call me morbid. Well, if someone is sick enough to zip someone into a suitcase, I don't think she would care if she kicked it down the stairs. Yeah. And I believe there was testimony talking about hearing sounds of like things hit something large, like hitting the wall and falling. Yeah, the neighbor said something like hearing about loud noises, like something falling down the stairs, if I'm remembering correctly. That's the same memory I have. So, you know. And hey, Polymopicus. Well, so with that, like, just plausibility is just, you got to look at stuff and be like, I'm not sure, Sarah. Like, you look at stuff and you're like, what you're saying and what I'm seeing with my own two eyes doesn't match. And like, I understand that people in this world like to gaslight people. Roy has never been too drunk to unzip as needed. Thanks for that overshare. I did not need to know. That's not. Cheers. Too bad this isn't alcohol. This is my new favorite obsession with sparkling water. San Pellegrino Chow. It's so good. They have a peach. They have peach, and I wanted the peach, but it was on the top shelf at Walmart, and it was 9:30 at night, and I wasn't about to try to climb on a shelf at 9:30 at night. But shopping at Walmart at 9:30 at night is probably the better, is the best time to go to Walmart. So the defense argued the appellee's expert witness offered new opinions at trial regarding the appellant's diagnosis, adjustment disorder versus anxiety, and the lack of PTSD criteria were not disclosed in her deposition. This constituted trial by ambush. Trial court found the violation was substantial, but denied the motion to strike or dismiss, instead allowing a mid-trial deposition. It was inadequate because the new opinions impacted the self-defense battered spouse syndrome came on a central issue after the appellant's counsel had prepared a cross-examination based on the deposition. This is where they might... once again, you don't have to like Sarah Boone to believe that sometimes she has a point. So the reality check of this is you don't get to prepare for a case and then have it change right in front of the jury. Unfortunately, it's one of those things of, even though I don't like Sarah, that is a constitutional right for a fair trial. And having an expert witness's testimony change between the deposition that you prepared to ask them about and their written statements or written opinion and report, which you prepared to ask them about, and then when they come and answer questions, it changes. That is not that's not an easy fix. However, the judge did give them a remedy. So it's not like the judge just said, yeah, whatever. It's this is Orange County, Florida. This is the same this is the same county that Leslie Federico lives in and filed all her lawsuits in. So You know, I admit it, you couldn't get Celsius to sponsor you, so you're trying for someone else. No, I actually had 2 Celsiuses today already, so I'm trying to stick to the recommended daily allowance for caffeine, which is 400 milligrams, and I've already hit that by noon. So I need to not go over that. But I still like the fizz or, something bubbly, but I don't like soda. It's gross. So I'm trying to see if I can replace that feeling of having caffeine in the afternoon with something that feels like caffeine. Same container. I got up at 5:30 this morning. So, live stream shopping with Squid at 4:30. Walmarts aren't open 24 hours anymore. If I was like 30 pounds lighter and didn't think that I was going to rip down the entire shelf, you might be right. But all the stuff that I like, this stuff, top shelf. The certain type of bread that I like, top shelf. Everything that I want is on the freaking top shelf. And I'm short. I'm 5'2". Angel's going to the bathroom again, so Mama might need to run. So, yes, baby. I will be right back. Once again, thank you for being patient with the fact that I'm a mom first, YouTuber second.
Our hearts beat to the city streets. We began to feel the fire. We rise like tall buildings as the chemicals they take us higher. The night's young and it's just begun as she puts her hand in mine. We wanna chase the night, wanna dance to the light, pull the stars from the sky, just 2 hearts running wild. Never sleep, never stop, every shot from the top. We're gonna be 2 hearts running wild. Now the morning is the afternoon. We lay awake in bed. The laughs so loud as the hours pass. We're gonna do it all again. We wanna chase the night, wanna dance to the light, pull the stars from the sky, just 2 hearts running wild. Never sleep, never stop.
All right, guys, let's finish this up, shall we? All right. I switched media profiles because I'm back on my court streams instead of I have certain ones for certain topics, and this is my main one. So I have a lot of my my old stuff on this one. The original stuff. All right. The 4th District Court of Appeals pointed out if the reviewing court finds that there was reasonable possibility that the discovery violation prejudiced the defense, or if the record is insufficient to determine that the defense was not materially affected, the error must be considered harmful. The jury was already exposed to the witness's change in testimony. The mid-trial deposition did not cure the surprise elicited by the change, and thus deposition did not cure the harm to the appellant. I don't disagree with that. And this was one of my things during my opinions during the original trial was I was unsure if that was going to be I thought the state super fucked up. The reliance the question that was pending to me, and the opinion that made this all better for me, was the expert had said, well, you didn't ask me about that in the original deposition. I was not, and I always say, when talking to a lawyer, when talking to cops, when talking to anybody, anybody in a powerful position, if you are not asked a specific question, I am not volunteering information. You will get a one or two word answer until you probe for more details. If you don't ask the right question, and this is where bad lawyering might have been a problem in the original deposition, which I understand James Owen's frustration because he was not her lawyer back then. But at the same time, it's not the state's fault and it's not the judge's fault that the lawyer who did the deposition didn't ask the right questions. You need to ask the right questions to elicit the right answers. I'm sorry, and this is why I think women are better lawyers than men. Hear me out on this one. And women in the chat, you can let me know what you think. Controversial opinion, but y'all can let me know what you think. Women are better lawyers than men in the long run because women never ask a question to anybody without already knowing some idea of the answer that they're looking for. Whereas men just willy-nilly ask shit. Just a thought. Just a thought. And hey, Heather, how are you? Y'all can call me I'm wrong. Tell me I'm wrong. Feel free to disagree with me. However, not that I'm a fan of lawyers anyway, but women might have the edge on this one because when arguing with people, we never ask a question that we already. Well, yes, that there are exceptions. Elaine, whatever her name was from Amber Heard, all I can remember is her first name, and Kathy Nestor in both Corey Richins and Tyler Robinson's cases. However, overall, we're not talking about the outliers. Because at the same time, you have Camille Vasquez. Just saying. Kranick did a pretty good job making this original trial ironclad in regards to appeals, and so you bent over backwards for Sarah. He did. He did bend over backwards for her. Women are better lawyers than men because they never forget the smallest thing. They can remember it 20, 30, 50 years later and hit you like it with it like it was yesterday. Trials, that's child's play. Exactly. You're wrong, not because you're wrong, but I disagree with you. Fair. So this issue might have been a problem with the original lawyer who did the deposition and asked the deposition questions, because the witness herself said, well, you never asked me that question. She can't opine on something that she's never asked. We know the answer before we ask. It only takes half a brain to be a lawyer, just saying. Sometimes no lawyer, or no brain. All right. While trial court relied on 3rd District Court of Appeals in refusing to strike the witness or dismiss the case, the appellant submits the Denninghoff case is distinguishable. In Denninghoff, the state appealed a dismissal of the defendant's charges based on a state's discovery violation and not turning over a report to the defense. That's different. It's not that they didn't turn over a report, it's her report changed. There's a distinction there. During the trial, a deputy testified on behalf of the state in reference to a report he had written that the defense was not provided a copy of. After the trial, judge conducted a Richardson hearing. The judge dismissed the charges based on the state's failure to disclose that report. In reversing the decision, the appellate court noted that the excluded report did not contain any contradictory information not contained in the other report that had been disclosed, and thus prejudice to the defense was minimal. Here, the appellant respectfully submits that the prejudice was much more substantial, inasmuch the appellee's expert witness essentially rendered completely different opinion during testimony than what she had stated in pre-trial deposition. As opposed to the Denninghoff case that merely involved a misdemeanor DUI charge, the appellant here faced a substantial life felony and premised her defense on her self-defense theory of battered spouse syndrome, where an expert wholly crushes that theory unexpectedly mid-trial and without disclosure from the appellee. I will give her lawyer credit, though. I might not like her and I might not agree with her, but he's doing a really good job at writing this. Like I said, not a lawyer. Lawyers might disagree with me, but once again, I don't like lawyers, so I really don't care. Cheers. Erroneous jury instructions were provided on the initial aggressor exception to the self-defense rule. Whether the trial judge erred in allowing a special instruction pertaining to the appellant's self-defense theory, the trial court ultimately agreed to the appellee's request to include the initial aggressor jury instruction, which negates the right to self-defense if the appellant was committing a forcible felony, like zipping someone into a suitcase. I can't say that zipping someone into a suitcase was ever written in legislation, but you never know. They might have a Sarah Boone law in Florida in the next decade or two. In allowing the special instruction, the trial court essentially directed a verdict against the appellant's self-defense claim and thus committed reversible error. During jury instruction review, disagreement arose between the parties with respect to the instruction involving the appellant's right to self-defense or duty to retreat. If at any time Sarah Boone used deadly force, she was committing an aggravated assault, or if at the time Sarah Boone used the deadly force, she was not in a place where she had a right to be, then the defendant had a duty to retreat. I mean, and this is where I think when I was watching this trial, my argument was against her self-defense and this duty to retreat was, if you are scared, you have him in a position where he can't move, call 911 and you say, he was getting aggressive or he was doing this. I got him in a position where he can't move. Here it is. Like, here he is. But she didn't. Instead, she recorded it. Wouldn't zipping someone into a suitcase be considered preventing their leaving the area by choice? Well, no offense, Gail, but the average adult will not fit into a suitcase. He was very, very tiny. Tiny. Like, why do I keep thinking about old Samsonite commercials? I don't know. And I'm just, and would you, and this is the point where this is semantics, I guess, but would you consider zipping someone into a suitcase aggravated assault? I'm sure there's something somewhere that, proves it one way or the other. It's one of those things you can argue over. While the appellant's counsel objected to aggravated assault language because she had not been charged with that in the information, that's the good point right there. The appellee argued that her actions constituted aggravated assault was zipping up the suitcase, exerting force through distance, and putting the victim in fear of death. That's a good point. And because she is on video, basically, recording him in the suitcase saying that he can't breathe, that would be fear of death. I don't know. Pelly's counsel notably indicated that he would have charged the appellant with aggravated assault and battery if he could, were it not for the statute of limitations had passed. In response, appellant's counsel maintained that Martinez v. State allowed the initial aggressor exception for jury instructions only under two scenarios, where either where an independent forcible felony was charged or felony murder was charged, and that had not been done in the instant case. So second-degree murder is not felony murder? Florida. All right. Hey, details. Details. I'm gonna check my phone real quick. Yeah. All right. The appellant was charged, or in Martinez, the appellant was charged with both attempted premeditated murder and battery after stabbing his girlfriend. Notably, the appellant did not object to jury instructions, included an exception to the appellant's self-defense claim if he was attempting to committing or escaping after the commission of attempted murder and or aggravated battery. After conviction and appeal, appellee argued that Florida statute allowing the special instruction did not require the independent foreseeable felony charge before allowing the forcible felony instruction to apply. However, Florida Supreme Court disagreed, holding that this circular logic would most probably confuse jurors because the apparent result in that instruction precludes finding of self-defense and amounts to directed verdict on the affirmative defense. That is understandable because I'm sure that would confuse me and jury member here. I mean, and that's why I like reading this. One, to know what's actually going on and not what the headlines tell us. And I also don't like when you hear actual lawyer reads. Like, don't give a fuck. I don't give a fuck. I want to hear what it says. I don't care what that person particularly says about it. Call me crazy, but when I see a thumbnail or a headline that says, or a title that says actual lawyer reads, it's very I don't watch that video because it's like, y'all are weird. Anybody can read a document. That's why they're public. I need a big one too, but only because my body doesn't bend like it used to. Yeah, that's I remember that 18 months ago when you said that I can't breathe, I left your stream. I remember that. That was a triggering trial for some people, and I understand that. I remember that. That was a long time ago. All right. This instruction permitted the jury to reject the self-defense solely because they believed she assaulted the victim by trapping him, which the exact circularity of Martinez prohibits. I mean, it kind of implies that, but her actions kind of imply that. But that's the thing. It's not always about what's implied. It's about what the law says. And sometimes it's like, you don't have to like the law. You know what I mean? Like, shit needs to be applied evenly. I don't have to like the defendant. And I don't like Sarah. Sarah is... Have you heard her jail calls? If you have not heard some of her jail calls, go to Jumpsuit Pablo's channel. He has her jail calls. Yeah. Yeah. The charged conduct trapping the victim in the suitcase leading to death makes the aggravated assault integral to the homicide act, not independent, rendering the initial aggressor foreseeable felony exception inapplicable and the instruction erroneous. I mean, this is where it will get interesting because not a lawyer, but that's an interesting argument to make. Thus, the appellant asserts this harmful error constitutes reversal of the judgment and sentence and remand for a new trial. Trial court improperly allowed the admission of the appellee's expert opinion on the ultimate issue of fact. Back to the expert witness. Trial judge improperly allowed appellee's expert witness to opine that appellant was not in imminent fear at the time of the incident in question. Such an opinion infringed upon the jury's role to be the ultimate trier of fact to whether the appellant was in fact in imminent fear. She didn't give a fact. She gave her opinion. And this is where it's like experts give their opinion for the jury to find whether their opinion is fact or not. So I think this whole argument right now is just bullshit. Like, this first paragraph right here is bullshit to me. And I think it's bullshit because of the fact that what he says, such an opinion infringed upon the jury's role to be the ultimate trier of fact. You just said it. It's not she didn't give a fact. She gave her opinion, and the jury can opine, or the jury can find whether her opinion is in fact a fact. There's something in every document that I read that I'm like, I can't believe this lawyer actually put this shit on paper and thought this was a good fucking idea. We had to go all the way to page 26. The rest of the document is pretty well argued, in my opinion. I don't know if it'll work. I don't know if I necessarily agree with it from a fact-finding mission. However, it was very well written and well argued. This one, well, the jury's the ultimate finder of fact. She can't opine on that. She can opine on whatever the fuck she wants to opine on. The jury can take her opinion and say, no, I think her opinion was bullshit, and not believe it. That's the jury's job, to take the opinions of the people who testified, experts, other witnesses, and find whether their testimonies were in fact bullshit or fact. And he contradicts himself in the same sentence. Such an opinion infringed on the jury's role to be the ultimate trier of fact. Well, she could opine that she didn't believe the defendant was in imminent danger, and the jury could say, well, I don't believe that witness. I don't think that witness's opinion was credible. Mother. You know what? This is what makes me think that lawyers get paid by the word. And the opinion was ultimately an improper legal conclusion, which negated the appellant's self-defense theory. It was her opinion. It was her opinion. She was testifying to what her opinion was. Like, the judge tells them right at the end that they can believe or not believe any testimony they want. Exactly, Snipe Hunter. Exactly. The witness usurped the jury's role as the sole trier of fact regarding the reasonableness of the appellant's fear. No, she gave her opinion. She gave her opinion and said, I think that she was not in reasonable fear or imminent fear. And the jury can be like, yeah, I believe you, or I don't. Oh, shit. He was doing really well, in my opinion, until then. As a general rule, the admission of a scope of an expert testimony rests within the broad discretion of the trial court. Indeed, an expert opinion does not become objectionable merely because it includes an ultimate issue to be decided by the trier of fact. Indeed, an expert opinion does not become objectionable merely because it includes an ultimate issue to be decided by the trier of fact. At the same time, witnesses will be prevented from expressing their conclusions when the opinion only tells the jury how to decide the case and does not help the jury determine what occurred. That opinion does help the jury decide what occurred because it literally says, I don't think my opinion based on what my talking to her, I don't think she was in imminent fear. It's so stupid. During the appellee's expert, Dr. Werner, she opined that circumstances surrounding the incident just prior to the victim's death suggest that the appellant was not in fear or of imminent risk or harm. 1 minute. Oh, sorry about that. Trying to stay hydrated, and it's making us have to pee a lot. Her blood was probably 100 proof when she zipped up the suitcase. Yeah. Appellant's counsel properly objected to the testimony, pointing out the expert was drawing a legal conclusion. That's not a legal conclusion. That's her opinion. Based on her education, her background, and her discussions with the defendant. Like, not a legal conclusion. Jesus, Pete. Trial court ultimately ruled that for the appellee and found that the provided testimony was not an ultimate issue of fact under the relevant evidentiary statute, and also relied on a case citation to overrule the appellant's objection. In essence, with this ruling, trial court allowed the expert to sway the jury precisely that the third district court ruled was improper to the aforementioned Schneer case. The expert's opinion was improper because it directly applied the legal standard for self-defense. Here's the thing, y'all. If just because the expert testified to something you don't like doesn't mean that it was improper. It just means it didn't go well for your client. And guess what? That's because she zipped somebody into a suitcase and left him there to die. The jury says so. It's not alleged anymore. I don't have to say alleged. The jury found that as fact. Jesus. Y'all just, yeah. The testimony went to the core of the appellant's self-defense theory. Yeah, which is why she testified to that and why the state asked those questions, because of the fact that they knew that her saying her opinion would blow apart a self-defense theory. Which is the state's job to make your stupid defense case blow up in smoke. Like, and then she recorded herself taunting him. Yeah, that was creepy. Yeah. And it's clear the opinion influenced the jury by the way of the guilty verdict. The opinion might have influenced the jury because they might have believed that before, and that was their final, like, oh yeah, what we think is accurate. Yeah, we agree. Oh my goodness. So this was filed the 22nd day of April by the Maldonado Law Firm. Y'all, this, what the actual, everything was, I was sort of agreeing with some of the things until that last part. He lost me. And I'm not like I said, not a lawyer. Will never claim to be a lawyer. I could not pass the bar tomorrow if I tried, unlike some people that claim they can. However, if I were to write a legal document and I wanted to be persuasive, the last thing I would put in the judge's mind is not my weakest argument. I would put my weakest argument, he had 4 arguments. I would put my weakest argument probably second. I wouldn't want to put it first. I wouldn't want to put it last because that's the last thing that the judge will think about when he's done reading this. I would put it second. Get it out of the way. It's there. It's not my strongest argument, but it's there. I would not leave that with the last thing that the judge puts in his brain is me making the dumbest argument known to man. This was like a Bubbles argument to me. I just couldn't handle it. Y'all, it made me just lose it. It really did just make me lose it because so what do y'all think about this? Because I am not really sure where this one is going. It could go either way. With this, just based solely on this document, it could go either way. And thank you to the one person who hit the like button or dislike button. You're awesome. I guess you're Sarah Boone simp, right? All right. So that is all I have for you guys today. We'll be back on Friday. Maybe tomorrow. Tomorrow, if it's a stream, it'll be a pop-up stream. But definitely on Friday to talk about teachers that make bad decisions. Horrible teachers. But at least I am changing the streaming time or the days I am streaming at least on a regular basis. Probably back to Monday, Wednesday, Friday, because life scheduling took some turns with work, with the days I work, what times I work. I train clients certain days, and I really don't want to do 3 jobs in one day. So it's an ever evolving thing. And when things get settled for summer and I have more family here and I have some babysitters who aren't working during the summer, I will be able to push out more content, more recorded videos, and more videos on my other channel. If you don't subscribe to my other channel, please consider it. It is my passion project. It is my career. We will have we will have content out Sunday night. We'll do a live stream at 9:00 Eastern time on Sunday night. I do have us set up to redirect over to Spawn. I have no idea what he's talking about. However, he was demonetized this morning for inauthentic content. Yet another one of those people who doesn't show their face on YouTube and got demonetized for inauthentic content. With YouTube just giving people the runaround when you tag them on Twitter, they just give you the runaround of a self copy and paste response. Like, read our terms of service. Yeah, what your terms of service and us don't, what you're trying to do doesn't help. So, yeah. Slow down, you do it one day at a time. I'm working on it. Work? Yeah, shush. I do want to get that other channel monetized, though. That is my goal by the end of 2026. to get that channel monetized, because that is my passion project. That is my career. I love it. That is where, that's my career. I went to college for that. I have certifications. I love it. To see the progress that people have made on that channel, from that channel alone, makes me so happy. But anyway, guys, have a blessed day, and God forbid, have the day you deserve. I'll see you on the next one. Bye.